The LA Probate Expert, and this is our Probate Weekly call we do every Thursday, 4 p.m. Pacific, 7 p.m. Eastern, and I'll have to repeat that because I'm in Los Angeles. It's 4 p.m. Pacific time, 7 p.m. Eastern time. ProbateWeekly.com if you're watching this on the recording and you want to come on live. We do this on a live Zoom where you can participate, ask questions, and come to the chat box. We do this, we also live stream it to Facebook and YouTube and other social media, so feel free to jump in there and catch it. So most weeks I like to have a guest, professional to teach us about the business. We've had vendors, we've had various other parties. I'm excited to have today an attorney, and I guess really there's two types of attorneys. There's those that when you're in probate, how to get you through the process, through the thickets and the mess that is the court system. There's other attorneys whose primary function in life is to keep you out of court by planning ahead and doing an estate plan. And so I'm lucky to have today with us a attorney that I've met and worked with the last couple of years and who is excellent, has some really innovative ideas on how to help plan estates so they can avoid probate, Liran Aliav with Aliav Law. So Liran, welcome to our call today.
Oh, thank you for having me today, Bill.
So I guess just to start a little background, like where you're from, where you grew up, and then how you get into law.
Yeah, so I was born, raised, and grew up here. Went to law school here, went to UCLA. So
Whoa, what? I missed that on the bio. Hold on 1 second.
I went to UCLA for my bachelor's and Loyola for my law degree. So
okay, that's good.
I've been in LA almost all my life, and so I was into back when in UCLA I was into a lot of mathematical subjects and some science subjects, and I eventually went on to law school, and I tried to mix both of those passions together with my writing and math ideas. And so I turned into this specific law field, which is the trust and estates law firm, the field of trust and estates, which has a lot to do with tax planning and property tax and all sorts of taxation issues, whether it's capital gains, and along with the probate aspect of avoidance and trying to get your family through the thick of the water without any hiccups.
Or as few hiccups as possible.
Exactly.
Good. So yeah, and so is that fair description that your job is really, or your job at your business is really to help people avoid some of the legal entanglements the probate kind of catches people up in their problems? Is that a fair way to put it?
That's the best way to put it. Usually, it's funny. You started off with, there's some attorneys that help you try to plan properly, and there's some attorneys that, too bad you didn't plan, and now you have to go through the probate process or some litigation. I actually do both, right? I do the planning, I do litigation, and it's pretty 50-50 here on both of those. So I definitely see how it is in court. I could use that to guide my other clients through proper planning, and I think that's the way to do it, as opposed to some people who just do planning, which is great. They might know how to plan properly, but I don't know if they see everything that you're supposed to see these days.
It makes sense to me. I almost feel like I would be heads up on some attorneys because I've been in probate court a lot and seeing the mistakes being litigated, and I see what the judge says live in person. There's something about being there and being in the trenches, I think, makes you more effective when you do both like that. So to me, that's very attractive. And so just to kind of set up for the callers today, we have 91 people and growing on the call. Primarily this is real estate agents and investors who are looking how to get more deals. And probate is one way to look at probate, which is you kind of like a miner, you get your pick in your little pail and your map. And in probate, that's your data, and you cold call, you talk to attorneys, you look for cases. That's one route. There's another route to go, which is if you're already in the business, talking to customers, bringing them value, and then in the course of that discussion, being a probate expert or real estate expert, and using those relationships to help you position you to get referral from business from them. And so I've used the estate planning attorney relationship as a way to position myself with my clients so that they'll say, oh, by the way, my family's selling a house, my friend's selling a house, my friend's in probate. So when you think about today how you can establish a relationship that benefits your clients might not be a lead right away. And so as I talk with Liran today, just think about how you could be bringing that value to your prospects, clients, as you talk in the process. So Liran, to me as a practitioner, not as an attorney, I can't give legal advice, but as a businessman, I would say almost any person who owns a property in California should have an estate plan. Maybe it's a living trust or something else, but it should have something that anticipates that they may be incapacitated or, God forbid, pass. Fair answer? Rather than buying it your own name, you should have something of a different strategy than that?
No, that's the perfect way to look at it. Is if you own any piece of real property, most likely your gross value here in California is over the minimum amount. And since you're over the minimum amount, you need something called the living trust or revocable trust in order to avoid the courts when you pass away or when you are incapacitated. There are proceedings, obviously probate and conservatorship proceedings that are done to move title from one person to the next, right? That's the whole point of probate, is to move title from you, who has just passed away, to your children or to whoever it is, through the process called probate. And at the end of the day, title is perfected in those people's names. Yeah. So we try to avoid that process by doing it with a trust. And once you do the trust, you don't have to go through the courts at all.
By far, and again, I'm not an attorney, so I have to be careful never to give people legal advice, but I'm allowed to give my personal experience and business insights. To me, by far the biggest misconception is, oh, I don't have to worry about a living trust or estate plan. I have a will, so I'm good. So go ahead. How would you answer that if you weren't giving me legal advice, but were you and I just talking in a bar after a couple of beers and we're friends? What would you say about that? Like, how wrong is that answer?
Oh, it's very wrong. So a will is what I like to call a ticket to probate. It's an admit one to going to court. With a will, you are basically giving instructions to the judge of what you want to be done with your assets. Now, those instructions, if you literally take them and put them into a trust, it does completely different things, right? It tells the judge, I don't want you to handle any of this. I'm going to do this privately in an office with an attorney or with my loved ones, and we're going to figure this all out so it's not in public records, one, right? You could figure out what Michael Jackson owned, let's just say, right? It's not hard, it's in the public records. So you get that out of the way. And then the fees of probate is the other major thing that everybody wants to avoid, right? On a $1 million house, it could cost you almost $46,000 for the fees to the attorney plus the fees to the person in charge or the executor. And that's minimum, right? So if there's more like sales of houses or some litigation involved in there, that's just raise that up and double, of $46,000 easily. So you want to avoid those fees by spending a couple extra dollars right now, getting yourself into a trust, making sure all your choices are done properly, and you effectively avoid all that hassle.
The way I describe it when people say they have a will is having a will is kind of like pre-printing the DMV forms and filling them out, being able to take them to the DMV. You still have to go to the DMV. The DMV still has to review your forms. You're going to make a couple mistakes. You have to go back to the end of the line or make another appointment, to use the DMV parlance. And it seems that a will, in some regards, it might even be worse, because unless the will is giving some specific change of allocation, it gives the opponent, the other side, maybe something to complain about. The signature's wrong, the notary's wrong, this is wrong, the wording's wrong. It's almost like you could even create more work rather than less work. Again, I don't want to make a legal conclusion, but there are circumstances clearly where you can go backwards rather than forwards, right?
Well, yeah, and when you do a will and a proceeding in court, it's not just your loved ones who could come and challenge anything. It's anybody, right? If, let's say, your friend comes in and says, "Oh yeah, Joe promised me the farm when he passes away, and I have I don't know, some sort of record that says it." Well, that could be a challenge to the will, and now you're stuck in court for another year or two at least. Especially right now with coronavirus, it's backed up, and you could ask Bill about that. I know he knows. Everything is set out at least 120 days from now, most of the time when you get any sort of hearing in court. So it's just a tough road to go once you have to go to court for any reason,
Yeah,
especially it's a will.
Yeah, I know we're
I'm
talking.
on a conference call. What's up?
Okay, sorry about that. I know we were talking the other day, and so for example, as a common procedure, when a wife is supposed to, I'm sorry, when a property is accidentally left out of the trust called the Hegseth petition, and people might learn, well, it's not a problem if it's left out of the trust. We'll just add in, we'll use this petition. But in LA County, Hegseth petitions are being scheduled out 150 to 180 days right now. So it's a shortcut. It's like the DMV. Well, you don't need to go on this line, you go on that line, but you're still going through the DMV, and it's still going to be a line of a bit.
And Bill, if you don't mind me saying about that, if you're gonna, when you're talking about a Hexstat petition, which by the way just means that you forgot to put something in a trust and you're trying to put something in the trust after death, it's if it doesn't work, you now have to go through probate. So you just added additional line to your probate in order to get something done, which I don't want to wish on my worst enemy at the end of the day.
Yeah, you'd rather be in the DMV than going through that, I guess.
DMV is only one day, so yeah, sure.
Depends what you have. It depends what kind of paperwork you have. Look, probate comes up with DMV issues too. That's a whole other area. So for everybody on the call here today, the goal is to be interactive. I want you to feel comfortable to raise your hand. If you have the Zoom app, you're welcome to do it that way. Put a question in the chat box. If you're watching on the live stream, I'll be checking there as well for any messages you might have. But the goal here is not this just to record as much as I like talking to Liran, is also for you to get your questions answered. We have a couple good ones. If I could jump in here, Liran. One is somebody said trust avoids probate and associated expenses. However, what expenses should be accepted? I'm sorry, I don't know why I'm not reading right. A trust avoids probate and associated expenses. However, what expenses should be expected for the administration of the trust assets, i.e., the trustee annual reports, trustee fees, and things like that. So there's costs for the administration of the trust. What are those in compared to, say, a probate?
Much less is the end of at the end of the day what you want to hear and what it should be. A probate is usually, again, 4 to 8% is roughly what you're going to be paying of the assets to both the attorney and the executor. When it comes to a trust admin, you're looking at usually 1 to 2%. Of the assets. Now, the percentage obviously varies because it's much lower when you bring me a $30 million estate. It's not going to be as expensive as you think about 2% of that. That could be pretty insane. So it just depends on what we're talking about. If it's like a house or something, it's obviously more expensive than if it's 10 houses, right? So
those fees are negotiable.
Hopefully that answered your question.
I imagine these fees are negotiable.
Completely.
Yeah,
it could also be hourly, by the way. Just so you know, there's some people that do it hourly.
Right. If it's hourly, there's less work involved. For example, in a trust, you're not typically going to court, whereas a probate, everything's going to court, or at least there's court appearances and fees and filings and such. So it cuts down to some of the administrative costs. But so the answer is it's negotiable. Look, wealth management companies charge me 1% to administer funds when you invest with them, stocks and bonds and things like that. So 1% to 2% sounds like a fairly reasonable number, but it depends on the assets, it depends on the administrator. And so in your practice as an attorney, you set up trust. Do you also administer trust? Is that part of your practice, or is that something that you refer out?
No, I do that. I do the administration, whether it's probate, whether it's trust administration. I set up trusts, I litigate trusts when we need to go to court over. Not all trusts are good, right? There's a lot of people that go on LegalZoom and pull up a trust, and they think they're all fine until there's a missing provision, and then I got to go to court and fix it, or some beneficiary is squawking over it, and we need to address it. That could also be another a year or two in court just handling that. So yeah, I do all the above when it comes to trust and estate, the types of work that you could do in this field.
Everything is good until it's not good. That's when you have a problem. so let's talk about that for a second. Right. I think we probably disagree on this a little bit, respectfully. Again, from a business perspective, you from an attorney perspective, and I guess it depends on what you see more of, right? I tend to see probably my business skews more middle income, and I would imagine trusts and estate planning tends to skew more upper income because you have more assets to be worried about. But to me, it seems that you're better off with a bad trust than no trust about 90% of the time. At least get something. Now, clearly, 10% of the time there's a mess, and I see that litigated in court, both attorney prepared and legal Zoom prepared trust. But it seems to me better for most people, if you have a simple situation, at least have something than not do anything. True or not true? Or make
I
your
would
case.
say, I would say, yeah, but there's a risk of it being way more expensive, right?
Right.
So you're rolling the dice at the end of the day. And yes, I'm coming from an attorney perspective that has been to court, been to trial over literal changes in trust, whether sometimes they're handwritten, sometimes they're done on the deathbed, sometimes they are done under some sort of fraudulent circumstances. And what we need to do now is go and depose everybody, and you have a bunch of lawyer fees. And at the end of the day, you're reducing the inheritance for the people that are getting the money. So I don't know. If it was done right, you wouldn't have had to gone through that. So that's the way I see it. And I think that it's an important point, and you might not be seeing it as much because, I mean, you're not part of those cases, but I do
Right.
see them, and they're very prevalent.
Well, I'm not looking for them. I mean, to be honest, right? I'm looking for the probate cases with litigation. I'm not looking for the trust. The trust cases get litigated, but I don't see. I'm not searching them out as much from a data point of view. So that's why I don't see that. I know my perspective is a little skewed, but I feel like there's no excuse not to get started. And I always feel like if you have a bad trust, get it done, then take it to an attorney and rewrite it. But at least now you have your names out, you have the data going. But you got to get into action and get something done to protect yourself. I think at the end of the day, we both agree on that.
Yeah.
So I have a question. That first, Christopher, I think that's a question of the month. That was a great question on the cost for the trust administration. I do think it's something that has to be thought about. Somebody named iPhone says, how can I find out how much it would cost to go through probate for a client of mine that's out of state? So the client's out of state. The property is in LA County, and that client's in Texas. So I think one of the questions to break that down is, if somebody lives in another state, but they have property in California, does it get probated here, Texas, or both?
It gets probated here for sure because the property in California, but the main administration is usually the county of the death. So you may have to do a main probate in a different county. So let's say New York, and then you would open up a sub probate, or what we call ancillary probates here, and that would take care of the property in California and eventually move it over to the probate in whatever other state you are.
I think, and tell me if I explain this correctly, when people ask me this, it's that the only way to change the title of the property is with a California court.
Right. I mean, California has jurisdiction over all California property, right? I can't go to Nevada with a judgment and collect in California. I have to go make it a California judgment before I could collect in California. Same concept.
Got it. Okay, good. And so how can I find out how much it will cost? So the answer is you have to find an attorney in Texas, number one, who's going to open up that probate and whatever's involved there. And the costs are going to vary based on the kind of probate and the issues and though it's cheaper in Texas than here and generally easier than here.
I'm gonna put a caveat on that. You're actually going to do Texas probate for all Texas assets. So whatever the rate is for Texas, you'll have there. But for California property, it's going to be a California probate, and all the rates here apply for that piece of property, right? You're not going to get double charged, but wherever it's at is where you're going to pay for that asset. And California is on a minimum fixed fee called the statutory, which is based on a percentage of the total amount of assets that are included. So if you die with 2 million, it's going to cost you more than if you die with 1 million.
Got it. Okay, and let's see. Winston Covington has his info. Thank you, Christopher. You mentioned a will can be contested. How does a trust avoid or prevent a challenge to the trust contents? So one answer, obviously, is the trust is private in the sense the contents aren't disclosed publicly as a course of process, as an ordinary process. So how is that primarily how a trust avoids a challenge? Is it, if you can't read the trust, you really can't contest it?
So, well, yes, that's for sure. But usually it's the beneficiaries that contest, or the people that were taken out of a previous amendment, let's just say. They're the ones who contest. There's no way to avoid a contest for a trust, right? If they want to contest the trust and they have ample uh, evidence to do so, you should think that they should be able to bring it to court, right? If they have evidence of video or something that shows that this guy had a gun to his head
Right.
and signed something, I hope that it comes to court and the court reverses it. I don't want that not to go to court. But what I do want to prevent is a lot of times when you have a trust and beneficiaries that, let's say you don't want to give equal, you want to give 40% to one child and 60% to the other child. So the one child is going to be mad. Obviously, he's going to be pissed off. He's going to look for ways to challenge your trust or your will. It's the same thing. It's the trust can be challenged in the same way a will can. But when you have the 40-60 split, what you do is you include a clause in there that it's called the no contest clause. And I know I'm going into legal mumbo jumbo, but it basically just says that if you contest the trust and you lose and you don't have something called probable cause to bring it, you will be disinherited. So now this guy has something to risk, right? He has 40% he's going to risk on this. Do I want to bring a trust contest or not? Do I have enough evidence to get over the hump? And that prevents a lot of frivolous lawsuits, which, if you know, in LA County, we have a ton. There's no shortage of just lawsuits flying left and right.
My late father was a civil litigator, and he used to say, anybody can sue anybody for anything. Doesn't mean they'll win. Doesn't mean it won't cost them a lot of money as a mistake, but anybody can sue anybody. So in a trust or a probate issue, any heir who feels they're shorted or thought they're in error could file a lawsuit. Doesn't mean they're going to prevail. And that's why you want to avoid things and to keep this private and quick and give people financial incentives to avoid litigation, as Liran said. Fantastic.
Mm-hmm.
Chris Ramos says,
sorry, just to add on, I just remembered something. When you also do a trust with in an attorney's office, you're pretty much guarding against all the ways that it could be challenged. Not 100% wise, but the three main ways are fraud. So an attorney, when you do it with an attorney's office, you're doing it in his office usually. There's not much fraud involved in there. There's another way you could challenge it is by something called someone influenced him to do so. An attorney can usually separate that influence and talk to them privately. So that takes care of that. And then you could also challenge on it wasn't signed properly, and in which case, obviously it was, because you did it with an attorney's office and a notary here. And it's just really hard to challenge attorney-made trusts. That's the point of the matter.
Got it. Very good. And just to tie that back, so somebody who wanted to come to you for estate planning purposes, if you were to create a trust, you handle all that. You have the ability to do all that in your office as far as the sign up and meeting, if there's multiple family members, and have those discussions that are appropriate and such. You can do all that.
Yeah. And we, tons of times I see family members come in with the signer and they're, speaking in their own language and forcing them to do things, and you separate them out and you try to see what they really want to do here. And if it's too much, then I would, there's points and times where I have to say, I'm sorry, I can't represent you because I don't want to take responsibility for you signing something when I know you're doing it under an influence.
Right. Wow. The drama of that must be fun to watch. We need to video that in your waiting room or something. That sounds like more fun than my job. Chris Ramos asked, if a client owns only one property, many times they don't feel there's enough to set up a trust and pay the fees to set it up. Is there a minimum? So is a minimum cost at which you would say somebody should pay the cost to have a estate set up?
I'm sorry, it's kind of hard to hear you.
Yeah, I had some.
What's the question again?
Question is really, is there a minimum that somebody should have to have before they set up a trust? If he only owns one property, and he's asking really two questions. One is there a financial minimum? The second is, I'm sure you have this too. Customers should get a trust, but they don't think they should. Is there a minimum, and how do you explain to somebody what the practical minimum is?
It's a good question. The legal minimum is $166,000 of net equity. The practical minimum, I would say, is not dependent on the price of what you have, but dependent on how you're trying to distribute it. If you have, and this comes up the most, which is a single person will call me and they go, "Oh, my plan is easy. I don't even have children." And in my head, I'm going, oh my God, your plan is definitely not going to be simple because now I have to go through all these family members and the what ifs and the what if, and it's just going to be pages and pages of things in there that you don't even know what's coming. But they always think it's simple, which is fine. I mean, it makes sense. I'm single, only have a house, but it's usually not. It's usually a lot easier when I have a child or I have two children. But either way, I would say that you're over 166,000, you should do it. And if you own a piece of real property, you should definitely do it.
I think I could say with confidence, every time I've had a probate case where there was litigation, had they had a trust, it would have cost them a lot less. I had one where a guy died, no kids, and his girlfriend claimed she was a wife and was promised the house and litigated on the basis that she was entitled. And obviously, if he had a trust, would have resolved the issue at least to some degree. I guess you could still claim she was married. Or other cases where other family members pop up saying they're entitled or they're promised things. The trust at least creates a stronger defense against those kinds of attacks at some level. Okay. So Ahmad asks, what do you recommend for young adults who do not own real estate, like own a car, retirement account, bank accounts, some crypto, etc.? So if they don't own 160, should they have a trust or is a will fine? Now, one of the areas we haven't talked about, we talked about real estate, which is our main focus, but from a personal level, there's also the issue of health issues, and what happens if you're incapacitated, and what happens after you pass. How are things handled? So maybe you can cover some of those issues. Not only just planning in advance is nice, but what are the other areas of control that you have when you have a trust that you might not have when you don't do that?
Right. So what are the main documents in the estate plan is really, I think, where we should start here. You have the trust, the will. I told you not to do a will, but you do a special kind of will with the trust. It's called a pour over. You have something called a healthcare power of attorney or a healthcare directive. You have a power of attorney. All four of these are documents that are essential to an estate plan. Now, you could take the trust out if you have less than 166, let's say, and just use the other three, and that should be sufficient for your life too. But the way I look at it is, yes, maybe today you're at $100,000 and you don't need a trust or a will. But when you pass away, if you're at $167,000, you need a trust, right? So you have to think of it in the future, and you might as well do a trust, unless it's someone's end of life and they're just trying to get something done and they have just a couple bank accounts, very low income, let's say. I don't know. Something along those lines, maybe you're good with just a will. But if it's anything else, I would just say have a trust. You set it up once. You don't have to think about whether you've created this trust, because the trust at the end of the day, what is it? It's a bucket, right? Think of it as a bucket, and you have to move your stuff in there. So 20 years from now, if you buy another piece of property, you just have to move it in the bucket yourself through escrow. You don't even have to call me to do that, right? You could. I would be happy to help you to move it in there. But through escrow, you just put it into the bucket. Through escrow, you put your bank accounts in the bucket. Not escrow, sorry. You just have to put your bank accounts in the bucket. You have to put every asset that you have inside the bucket. And then you just change the terms of the bucket as time progresses, so a couple tweaks. Oh, I have a new child. I want to give more to this charity. Those are tweaks that you make, and you just tweak it up every couple of years. But you don't have to recreate the bucket anymore once you make it. So you might as well just do the bucket. Did I answer all the questions? I'm not sure.
I think you did. One of the saddest days I was at probate court in the research room one day, and a guy came in tears, and his child had a girlfriend who was visiting from out of the country, had a terrible accident, was like on life support, and I don't know if they wanted to turn it off or turn it on or whatever the story was. They had no control because the parents were, I think, were in Japan, and the girl, they had no legal process. Where if at least in America, if you have a trust in that situation and includes the medical directives and you pre-plan those things, you can effectuate whatever you want done. But it was just heartbreaking. So there's advantages to having this preparation done before, beyond just the money side, which is important, as well as your personal choices, whether it be what happens when you're gone or also while you're alive, to give people the right power and choice over medical decisions and things like that. I can imagine in my case, we have a new grandchild, and we have, my wife and I are married, and then we have my son-in-law has parents. And so God forbid something happens to my daughter and her husband, who would, make decisions for the child. And that's complicated. And so those are kinds of things that have nothing to do with the money, but have to do with the kind of life you want to have. Okay, another question from Christopher. Christopher's last question was great. Let's see how this one is. How often have you participated in a probate or trust litigation where the losing party lost their inheritance due to the non-contest clause you mentioned? Is that a common thing that people face that clause, litigate anyhow, and lose? Have you seen that happen?
Yeah, so I could recall exactly one case that they actually enforced it against recently. Um, it happens. It happens a lot. But a lot of you got to remember, litigation is a long road. It doesn't, and not every litigation case results in a judgment. Uh, Most of them, I would say 95% of them, settle somewhere in the middle, right? Somewhere in the middle, we go into a settlement agreement, mediation, something, we settle the whole case, and then there's no contest clause because we settled the whole case. Everybody went their own ways. But should you go to trial and should you get a judgment, and even during trial, sometimes cases settle. Yeah, I know of a case where uh, a guy completely lost everything in his, and he had his substantial assets in there, and the judge, when the judgment came out and said, no probable cause, you're losing everything. And that's just the name of the game. And that's the dice he decided to roll.
And this wasn't your client, so usually it's the client took the advice of attorney not to litigate. He did it anyhow, and at the end, it didn't work out. So I've seen that happen.
Yeah.
Okay, Josh asks, interested in the best way to get probate leads for a real estate agent. Josh, that's something that's not really Liran's bucket. He's not really involved in that process. If you go to my website, I have under resources, probate resources, a list of the different data companies that I'm aware of, some reviews of them, some videos of them. Or if you want to reach out to me individually, I'd be glad to share with you how we get the data. It depends on where you are, what you're going to do with it. So that's not really, Liran doesn't buy probate data leads, filings, or those kind of things. He files cases on the other end. What's the starting rate for simple trust? And I asked the question, another question, which was what's the typical cost for an estate plan? So obviously price varies, the circumstances and such, and but you also kind of get what you pay for. You can go online and see what LegalZoom's rate is, but you get what you pay for there. Can you share kind of what the basic cost structure looks like, or what that looks like financially?
Yeah, sure. With trusts, you have to understand that there are protections that you could add on to them for your beneficiaries, for your children, that you can't do to yourself. Right? So you have creditor issues for them. You could help protect against divorce. Creditors, you could help use. Let's say they're getting special needs treatments from the government, or they're getting some sort of public benefit that you want to preserve with the inheritance. Those are all going to increase costs because it makes the trust more detailed. So there's no set price for what I do for trusts. I could give you guys a general range. Usually it's $3,000 to $6,000, with most of the families coming in on the lower end of that spectrum. But that is the usual range I see.
And really, the more expensive ones are for very more sophisticated and important and valuable needs. So you're talking about saving tens or hundreds of thousands of dollars if you're able to effectuate, saving the resources for the family. So somebody has a
The way
question
gas
though.
prices, oh, sorry.
Yeah,
I was going
gas
to say,
prices.
with the way
Yeah,
gas prices and inflation is going right now, I don't
yeah.
know how long these prices are going to stand.
Yeah, that's a good point. As real estate agents, the house goes up, so our commission kind of goes with it. But for attorneys, people complained about your rates a year ago. The inflation's gone up, 15, 20%. You should be raising your rates too, probably. Might be a good point in time. We have some more questions, and I don't know how much time we have with you, Liran. I'm glad to continue. But just for anybody who's jumping in here, if someone wanted to reach you, Aliav Law is website, ALIAV law.com. And on there, he has, describes himself and his background. And also has a box. If you want to book a call, you can click right on there and you can set time to talk to him about your individual needs. Also, he has a webinar that I've watched that explains kind of the process and how he works. So again, Aliav Law, and Liran is based here in Los Angeles. So that might be answer some of your questions that are more personal that we really have to go into on a phone call like this. How do you remove an heir from property that's sold upon the death of the owner of the estate? So you have a property where the title is remove an heir from a property that is to be sold upon death of the owner of the estate. I'm not sure if I understand that question, Sandy. Do you understand the question, Liran? How do you remove an error
I'm not quite sure because what do you mean by error? If
and
you're
remove
trying to
him?
remove an heir, the heir is alive, right? Or are you talking about a deceased heir?
Yeah, I don't know. If the property is supposed to be sold upon death of the owner, Sandy, maybe you can unmute or wave your hand or something. I could call on you. Let's see if you're still on here or not. I can unmute you and maybe you can kind of explain the story the situation a little bit. I'll ask you to unmute if you can, Sandy. Maybe you can ask the question. And if not, we'll go on.
I mean, just in general, if you're trying to remove anybody off title, he has to have been passed away. You can't just remove alive people from properties. Uh, that was an issue for one of some recent caller of mine. So
Oh, oh,
really fun conversation.
oh, wow. Okay. Hand up Hector Aguilar. Let me see, I have to unmute you. And I just unmuted you. Go ahead.
Hey, good afternoon, good afternoon, Bill and Liran. Thank you for putting this together. Really quick, I have a situation where a client I spoke to just a few days ago, he was contacted. Grandma and grandfather owned the property. Grandpa died about a year ago. She died about a month ago. And there's a son that lives in the property. It's a two-time felon. Has already told everyone on the property that he's not moving out. What kind of steps can be taken? Obviously going through the probate process because they didn't have a living trust. Protect that particular asset. So they have to go through that process. But what is the situation with regards to removing that particular person from the property once the administrator, or at least once they get full authority on the property? How's that?
Well, this is more in lines to an eviction attorney. That's for sure. Luckily, I do some evictions, so I do know a little bit about it. Um, so it depends on the county. It depends on the coronavirus rules in that county. It depends on if there's a lease agreement. So you got to take a look at all that. You might be able to evict them based on something called tenancy at will, which means that the guy is there without a lease. And then you need to give the proper notice, and hopefully the county hasn't abolished that for coronavirus, and those rules are still not applicable. But the short version is just I think you should give me a call, and I could take a look at more detail and see what we could do here. There could be something at the end of the day. It just what's important to know is who's in charge of the will, who's in charge of the probate, is it the son? Because
It's actually no, it's not the son. It's the
okay.
grandson who's going to actually be the administrator. The
Going to
grandmother
be
was
or
working
already
some kind of
the administrator.
sorry, there's I guess the grandmother had already started talking to an attorney about it. She passed away unexpectedly a few weeks ago. And so now the attorney's reaching out to say, hey, you know what, your grandmother wanted you to be the administrator. I need you to take some processes here. But, he doesn't trust that attorney. He doesn't know who he is. So he's reaching out to me because I've known him for years. So just wanted to ask the question. Definitely will reach out to you on a more private note. But
Yeah.
I know he's going to be, he's going to have his hands full with that eviction and that whole situation. So just thought I'd
Yeah,
ask.
and I'll just let you know that this during these times, the answer could be there's nothing you could do,
Right,
and which I have to give a lot of landlords that kind of advice these days. It's
right.
especially in
Well,
LA. I don't know if it's LA County, but
I'll say this before you give up,
Thank you.
call me because I've had two situations where we had one case, the tenants from hell, the other one, somebody claimed to have a personal relationship with the decedent. And, there's some things we were able to do to get them out in both cases. So I'd say before you give up on that, Liran and or Hector, call me. I might have some ideas or have a vendor that can help you.
Thank you.
Some ideas and some things you
Yeah,
might be able to.
unfortunately, the property is in LA County, so I'm sure that it'll fall into any one of those A through Z categories for COVID.
Yeah, no, I mean, I think every deal I close now has some sort of a tenant component to it. The one way or the other you have to deal with them. It's
For
challenging.
landlords and owners that are struggling with that,
Yep.
I mean, there's just no end in sight, at least not in the short period. I know something about June this year it's supposed to stop, but who knows?
I can tell you, being involved with the politics at the low level I don't think it's ever going to stop. I think the politicians like this control, and I see this being increased, not decreased. I think going forward, but
And a problem for homeowners. I'm in a contract right now that I've been in a contract for now 9 months, tenant occupied. They've already got the writ of execution from the county. Or from the court. He didn't even show up to the court appointment, but at this moment they still haven't evicted him. So
right.
Who knows what's going on with that? But yeah, landlords and owners of properties with tenants are in a real bad position right now, unfortunately.
Yeah.
Thank you for the answer. Appreciate it,
Yeah.
Ron.
Of course, of
Thanks,
course.
Hector.
Good luck.
Okay, let's see here. Here's another question. I see this happen too. I'm sure you do as well. So the property is under sibling A's name, but the payment was being made by sibling B, right? So one brother's living in the house, the other one's making the payments. The sibling A has the property put in a trust. Well, this doesn't make sense. How can sibling B be able to get rights over it? Is that even possible? So if you're making payments on somebody else's property, I guess there's really not much you can do. But if you during the time of the probate, where it's unclear who has control,
Who died?
yeah, that question isn't even clear. So I'd say, Asma, I would need you to kind of jump on here. We can get a little deeper on this, but I don't think there's enough information to answer. I'll unmute you.
So hold on. She said no one died, or he said no one died.
Oh,
No, actually,
That's a real estate question. That's a real estate attorney question. Just so you know,
okay.
because
It's
I
in a-
deal with when you passed away, right?
I just had a quick question. The house is under his sister's name. The brother has paid, it's completely paid off, practically. It was a new construction home. The brother had actually paid for the new construction and everything, and the sister had put it in a trust. The brother has been living there. It's under the sister's name to kind of like avoid any lawsuits that might have to the brother. Does the brother have any rights over that house?
Who's on title? Who's on title?
The sister is on title.
And does the brother have any rights? I mean, he could have rights by showing payments in court and the court quieting title to the property. But that's again, that's a real estate question. It's not something. If the brother died or she died, then I would say, hey, you need to go and file something called a creditor's claim in the probate. But we're not there yet, so I don't particularly know what procedure you're going to need. Off the top of my head, I think you need a quiet title, something like that.
So is that something that could be like, that has to be litigated before someone passes away to make sure that they get the rights? How does this work?
Whenever you discover a problem, it usually starts something called a statute of limitations, which means you only have X amount of years, or 2, 3, 4 amount of years to bring a case. So that could trigger a statute, and I don't want to tell you what it is because I have no idea. And you should go consult with the real estate attorney who could give you a better idea of what you need to do and how much time you have left.
I see. Okay. All right. Thank you.
Mm-hmm.
Thank you, Asma. Okay, so there's that one. No, I don't think so. Does a trust create an umbrella or protection against lawsuits?
A revocable living trust? No.
So it really, whether you're sued or not, the trust doesn't really change that. You're still subject to it. Now, it doesn't have something to do though protecting. Let's say you have siblings and heirs, and money's distributed like one against the other, perhaps against the parents' assets because they're separated out. Or I've seen some discussions as to how to give money to kids and also to avoid. If they have lawsuits, you can give them income rather than giving them the assets. Of course, if it's in the trust, they may not know that they're beneficiaries of the trust as well. There's some privacy issues.
So you're talking about parents owning property or parents owning assets and putting into a trust for their children?
Maybe to avoid creditors or avoid lawsuits.
Okay.
And things.
So you have to understand the main concept, which is if you have a revocable living trust, you're not doing asset protection. Asset protection is something else. There's different kinds of trusts that help you with asset protection, and there's also asset protection is like a buzzword, right? It's like, oh yeah, I want asset protection. Well, asset protection could be seen as, oh, I want to avoid the courts and probate and when someone passes away. So that's the living trust portion. But if you want to avoid creditors and if you want to avoid divorce for, I don't know, some divorce issues or actually, here's the more important one, privacy, right? So if someone wants their names to be private there on the records, you guys all know how to check records on brokers could easily find who owns property. But if you see ABC Trust owning the property and the person in charge of the ABC Trust is the XYZ LLC, and there's nothing to associate, you guys have all been there. You're trying to find the owner, trying to contact the owner, you guys can't. because
Right.
it's done properly. It's done called what we call the privacy element of this asset protection. And I do this a lot, especially with people that own a lot of property. It's usually done for income properties. What we call these are land trusts or blind trusts, or there's many other names for it. But what we do is we separate each property into trusts and create different LLCs in different places that are very advantageous to you, gives you asset protection for lawsuits, gives you privacy protection. I think that's probably what you're looking for.
So
It's
get
not a regular living trust.
right. So this again gets to why someone would come to you rather than just LegalZoom. Maybe LegalZoom could do all these things, but you're not going to know to ask for them. They're not going to give them to you. Whereas an attorney's going to look at your whole plan and what your assets are and what your situation is, and design something that's appropriate for your circumstances. It sounds like.
Oh yeah, yeah. Each person, depending on what you own and your family dynamics, your son and daughter, how much you guys come, how much you guys, what kind of relationship do you have with them? It's all going to drive my work. So yeah, there's almost never the same trust for the same people. It's always there's some sort of tweak in each one.
This next question is right on point and classic. Is Claudia asks, I have a question. Home's in her name. She's married to her husband, and that's a whole other thing. Were you married before or after you got the home? And my husband has 2 kids. I have 2 kids. That's a whole nother issue. I don't have a living trust. What happens if I pass? I don't have a living trust yet. I know the answer to that one is, well, who knows?
Well, yeah,
Just
but
based on those facts, who
also
knows?
based on those facts, you need to go see an attorney ASAP. That's like the fire alarm of all alarms. You have
Yes,
mixed
yes,
family, you have
yes,
property, you don't have a
yes,
trust. You
yes.
need a trust. You just need to
Yeah.
get it done, and then you don't have to worry about it, right? You want
We
it to
have
go
mixed
one
family
way,
with
it's
mixed
going to go
family.
one
You
way.
have a marriage and then you have other kids. So and she didn't
Blended
even say.
families. Mm,
Yeah, and that's
yeah,
not to say they're bad or there's anything wrong with them. It just means that they don't have the same emotional investment in the parents and the spouse, so that when something comes up, they're more likely to feel cheated, hurt, or financially go after somebody. It's not about, and Claudia, I don't mean to in any way disparage your family or kids. It's just that these are different legal issues, and there's also different emotional issues behind them, right?
right. And just so you know, it's just there's several just red alarms that you need to trust or you need to go consult, and one of them is blended families. I that's just go see somebody. It'll do very well, whoever it is.
Um, so here's a classic question I get a lot too from Dean. Can you just draw up an addendum to the trust and have it notarized, or do you recommend having an attorney write the updates and or adjustments? This is a classic question.
This was the same case that I brought up before, where someone tried to do this themselves, and there were all sorts of problems with what he meant. And now we had to prove intent of what that person meant when he's not here with us anymore, or she wasn't here with us anymore. And if you guys could just wrap your head around that, that's just really hard, right? How do you prove intent of somebody who's not here, right? Um, so what
The answer
happened
is you have
was
to hire an attorney and go to court.
right,
That's
but exactly, exactly. You have to hire an attorney, go to court, but it's going to cost a ton of money. It costs the family, just so you know, it cost the family $300,000 for the legal battles between everybody. Because this guy wanted to do, okay, I wanted to save a couple $100 or a couple $1,000, whatever it is, on some work, and that's what usually happens. And that's what we want to make sure it doesn't happen to you guys
yeah,
with
yeah.
these trusts.
Yeah, I had a discussion with my son-in-law last night. He's a tax preparer for a large wealth management company. He was saying he had a client who, to save money, used they weren't even licensed as an enrolled agent. They were not legally allowed to do taxes. And the client mistakenly was then given a certain type of tax structure, a C Corp instead of S Corp, and was going to pay tens of thousands of dollars in extra taxes and fees to have saved a couple $100 in the tax preparation fees. So one thing I've learned definitely is that great advice is definitely worth the fee many times over. Here's another question. I think this is right for I feel like I'm throwing you now underhand pitches to hit. Can I establish 2 trusts, a blind trust and a family trust, or discretionary trust? The family trust is under the blind trust.
So with most plans, you're always going to need what I call shoes, right? And what are your shoes? That's the basic plan. You're always going to need the living trust. And now you could add on trust, and you should add on trust, blind trust, land trust, irrevocable trust, whatever is needed on top for each specific situation. It's not just one trust for all. Sometimes it's, I mean, I have a client that has 15 trusts, right? And each time he gets another property, he makes another trust. And that's fine because no one knows that he's going to own these properties, because in the title, it's not going to say his name. It's not going to say his address. And that's what people, you know, want at the end of the day. They want privacy. That's and another thing, just so you know, I know I saw in there somewhere someone talks about LLCs. I know California LLCs are pretty expensive, and when you have property in California, you need it to be owned by a California LLC, and if you do like a Wyoming LLC or a Delaware LLC, you're going to have to register it here, which means you have to pay the fees here at the end of the day. And $800 a year fee is going to apply to you at some point in the future, and even if it's later, they're going to back charge you for all the time that you need. But there is ways to do trust and LLCs in different states that work together. And I found that most people that looking for these kinds of privacy protection, they like that option for all their properties, because they don't have to pay the $800 per property, which is insane. Plus, just have you know that California LLCs are the least protected or asset protected place in the world, in the United States, one of the worst ones. You could pierce through them very easily. So I don't know, a lot of people are like, oh, I should put my stuff in LLCs. Maybe you have multiple owners and you want to do something and make it easy, sure. But it's not the situation for every person, that's for sure.
I see oftentimes, customers having trust, the Bob and Mary Smith family trust, and I see other ones that are more random, the Mickey Mouse 613 family trust.
Yeah.
What are the advantages of one that identifies you clearly by your name or you and your spouse's name, versus what's the advantages of having it be random or unrelated to you personally?
Well, it all begins with what are you trying to protect, right? So most people like to protect against lawsuits. So what happens with lawsuits? You have to look at it from an attorney's perspective, because the attorney is the one who's going to initiate this thing. And what do? We do some research. We go find out what your assets are. We go look up title. We go see if we think it's a good place to go, unless you have insurance. So obviously we're going to go after your insurance. But if you don't have insurance, we try to see what you have and see if it's a good case to go. Otherwise, we'll just say, sorry, go to another attorney. All right, that's the usual way that at least contingency attorneys find out good cases. So if I can't find your name on any property, I'm less likely to sue you. And that's the whole point of privacy and doing these kinds of trusts that will be very helpful for that sort of implementation.
Winston has a question. He's a real estate agent like I am. And so he's asking you, do you find that most personal representatives are going to be families, have their own real estate broker connection, or do attorneys, you and your associates, typically have relationships, a preferred list of brokers that you refer to that understand maybe the probate or trust process? So how does it fall out, in your mind? If you don't mind sharing, what percentage of the time is the customer come up with somebody and that works, and what percent of the time are you saying, well, really this requires a little more expertise than your local real estate expert, and how do you handle that?
With real estate brokers, it's a mixed bag, because sometimes the seller really wants to use the broker, and it doesn't matter what I say. I don't care. They don't care how much experience they have with probate, and there's nothing I could do because it's ultimately his choice. I prefer to work with people who have done probate sales. They're not easy. They're not the same thing. Some people are like, oh, I just need a couple extra forms. Well, maybe, but if there's hiccups, the brokers are usually the ones that know what to do, right? The ones that could do things without even talking to me, right? And that's very valuable in my field, because they could just get it done without having to use my time, right? Or charge the client for my time. And especially when you have a probate limited sale. I don't know if you guys know what that is, but when you don't have the powers to sell freely, you have to go through a court confirmation process and a court auction. And those are so tricky, because if you miss one small thing in your agreement, you're overcharging, you didn't list it at the right price, you didn't put it on the market for enough time. It just cancels the whole thing, and you have to redo the whole thing again. And it's just no buyer wants to wait that long, and it just creates a lot of tension and problems. So yeah, I prefer most definitely to work with brokers that have a lot of experience with probate. It's the best.
Well, look, you've been really generous for your time here. Just to wrap up, we have a bunch of unanswered questions. You triggered a lot more interest than we can cover in the time we have. So on behalf of everybody on the call, I want to thank you so much for sharing your expertise, your knowledge. And again, if you want to get in touch with Liran to talk about your personal needs, Aliav Law is in the chat box, and you can go there. And also, we talked about on our interview that you're one of those attorneys where if they click on to set an appointment time, you'll actually be the one that talks to them most likely about what their needs are and give them a consult to help them get the process started.
Right. I will be the one. Most of the time it goes through my assistant. They screen some questions, and then I'll give you a call thereafter. So if it's something I can handle, definitely I'll give you a call. And just so you guys know, there is another webinar that I think you probably would be interested. I'll put it in here. It's a webinar about asset protection. And you're not going to find that on my website. So
great.
You guys could watch it there.
Fantastic. And we will also put it in our description. So if you're watching this on YouTube or Facebook or whatever systems, you'll find that there as well, hopefully. Well, look, thanks so much. Just before we wrap up, I just want to tell for those who are licensed real estate agents, we have a live event that I'm a co-host of in Diamond Bar, California. It's agents helping agents thriving in a real estate during this transition period. It's in the Diamond Bar Holiday Inn at the Gateway Corporate Center. It's free for a real estate agent. We have Carlos Gutierrez, who is number 2 in our company, did $60 million plus in sales last year. We'll talk about how to list property focused in luxury. So if you're interested, reach out to me, and I'd be more glad to give you that information. And again, Liran, thank you so much for your time today and your help as always. Really appreciate it.
Of course. You guys have a good one.